You're actually one of 3 conferences going on right now. We have a pretty significant conference going on in the next stages of fighting terrorism, which Scott Sullivan is running, and then next door, or two classrooms over, is another conference going on in behavioral genetics and criminal law. So a lot of activity here this weekend, and we're really pleased to have this high-level conference among them. You are in one of our newer classrooms. We're in the process of a series of facilities improvements, which have included renovating these 3 large classrooms, the smaller classrooms upstairs, and then this new wing here will have 4 floors, 2 of them faculty and interdisciplinary centers, also a floor for clinics and another floor for law journals. So a lot still going on, and there's some projects after that as well. But please feel free to wander around and see what we look like if you haven't been here before, and even if you have, we've probably changed substantially.
I was too fussy.
It's really good to have you all here. I think my job is to just get up, welcome you, and sit down. But I'm going to turn the podium over to Roger Crampton. I wasn't told I needed to introduce Roger, who's disappeared. Oh, here he is. But since you all know who he is, other than being a superstar in the legal profession area and conflict of laws, perhaps one of his most important attributes for this conference's purpose is he's a very good friend of Paul Carrington's, who's been with him long enough to know which of his ideas the world needs to be protected from, and which ones warrant a full conference. So I think he's a very discerning man, and I'm going to turn this over to him now. Again, welcome.
Thank you, Kay. Well, I haven't always succeeded in reining Paul in, but he hasn't succeeded in reining me either. We are both gadflies, kind of law reformers by temperament that always want to put our hand to trying to make things, as we see them, better than they are now. Well, you know who the first 2 speakers are. We're starting off with Consequences of Life Tenure, and we have a lot of data, which some of you are familiar with and others are not. Jim Lindgren has compiled all that data and is going to tell us about it and maybe draw some conclusions from it. And then there's Ward Farnsworth of Boston University, who is going to follow up.
Okay, let's have some fun with numbers here. The age at death or resignation by the period of leaving the court. What we found when we looked at the data, and Jeff Oldham did the first inputting of most of the data, was that as the age of death or resignation after the first period of 31 years was pretty much flat from around 70 years old, and then jumped up to around 79 in the last 35 years. Then we looked at how long it had been since a vacancy on the court, and we found that again, there was a phase-in period in which vacancies were very quick. The court was not in high repute necessarily, and people weren't accustomed to taking this position. Then we had one period with very long tenures, relatively long, which was 2.63 years between vacancies. Court was also smaller then in size, which is one of the explanations. And then we settled down to basically 1870 was when the courts finally settled on 9 justices, and we see from the 1881 period on, it was pretty flat until just the last 35 years. Then the mean age at swearing in by period of the court, again, the ages were rising a bit, and then they've been falling, probably some strategic behavior, but of course these numbers are pretty much flat and not statistically significant, any of these changes. But you can see that contrary to the sort of belief that we're picking much younger justices, in fact it's not much, it's only a year or 2, 3. I ran this one for this, which is not in the paper. And this looks at the last 9 appointments. So although years are at the bottom and they're related to when these happened, they're not, the scale is by appointments. So 9 appointments, and you'll have a setting at the bottom. It's not proportional by time is what I'm trying to say. So we can see that, that if you look at the last 9 appointments, it really was around 2, and for much of our history, under 2. The peak over here is actually a peak for the 9 old men court packing plan. So that was the prior high. And we exceeded that in the late 80s, and now we're at 3.75 for the last 9 appointments, which is basically double what the pattern was before. I also looked at some of the proposals. Since I'm on first, I thought I'd just lay out some of them, and some of them required doing. I've spent much of the night running phase-ins, and then this morning saw that the Carrington-Crampton proposal had been changed, so I physically got it at 5:2 on that clock, and we started at 3:2. So I actually wrote 2 phrases about it, but I think they're right on terms of phase-in. So first is the law student note from Virginia, James DiTullio and how do you say, Sochet or Shockett? I'm sorry, John Shockett, published in 2004. They provided for 18-year terms by constitutional amendment. Terms expire on January 3rd in even-numbered years, which is election years. There's potential for an election problem. Most of the time, since they provide for earlier decision, that is, you can appoint them in the 6 months before, I think they're anticipating they'll avoid it. But there's a chance that there might be a little bit of problem there. The statute takes effect July 3rd of the next odd year. The presidents are not grandfathered, and the existing justices are not grandfathered for life tenure. And that's a big difference from how phase-ins are generally done. For example, the 2-term limit on presidents, where there was an effort to grandfather Truman. And so that would be a change from how things are usually changed when it's something as basic as this. And existing justices may be limited to less than 18 years in some situations, depending on the phase-in. And then after phase-in, the replacements will serve the remainder of an 18-year term. So once you've fully phased in, if someone should die or leave office in the middle of office, they don't get a whole new 18-year term. They're replaced by someone is appointed to replace the rest of the term. That's something that Calabrese, Steve, and my proposal also has. They have one thing that's unusual, and I don't know what it means exactly. I don't know whether it's meant to be a change or whether it would just be one in form, but not in substance. But the Chief Justice shall be appointed from among the Associate Justices. I assume someone could be appointed to the court and then appointed to Chief, so I'm not sure it makes that much difference. Phase-ins are relatively quick, as you might expect, given that there's no grandfathering. They start basically in 1 to 2 years, depending on exactly when the statute passes, and they end in about 17 to 18 years. It can be as much as 20. But you start looking at the phase-ins of the original length, and one of the things I did was I'm one of those people that is seldom persuaded simply by argumentation. I like to look at data, and I like to think sort of more by osmosis, working up, trying to absorb things and sort of inductively thinking about this. And the phase-in lengths of term, and I computed this for all 3, well, several proposals. For their proposal, if the statute had come in force when Roosevelt came in, the appointments, the 9 appointments that would have resulted in the phase-in period would have been of 2 years, 3 years, 3 years, 5 years, 12, and the rest would have been in 18-year terms. If it started when Truman came in, it would have been 3 years, 6 years, 9 years, 13, the rest 18, 1953, and so forth. I think that's troublesome. I think that having very short phase-ins is a problem with 1-year phase-ins of 1-year terms. So I do think that not grandfathering is one thing, but also having very short terms. Now, this is not a situation where somebody's dying in office. If they're dying in office, then you can expect a short term here or there, but that's a lot of them. Then Carrington and Crampton, which they've had several proposals, and one of the nice things is they've been very open-minded in hearing suggestions, taking suggestions, and being willing to alter. And the original proposal was for 16-year terms and implementation by statute. The next proposal was December 17th, 18-year terms, and the terms begin and end at the discretion of the President and Congress in a 2-year window. So that meant that every proposal in current law, if the Congress wants to be, or President want to delay, they can, but they have no power to actually knock someone off the court from sitting cases. This original proposal, they actually, within the 2-year window of the congressional term, could strategically knock someone off in the first month or in the last month of a term. Okay, phase-in was unclear, and I think they intended to wait until all 9 resign. If not, actually, literally, the proposal provided that you'd start appointing justices, but they wouldn't hear cases because the existing justices were grandfathered, so you could have a shadow court that didn't hear cases. But they probably meant to wait until resign. And then the later proposals, 3.5 and 328, provided for that. 18-year terms, implementation by statute, terms begin and end on August 1st. Phase-in was no appointments until after the last of the current justices leave the court. They're going to wait until all 9 die or resign, then begin transition. That means transition starts after 27 years and ends after 45 years. And I checked last night on the web, and this is the version still up on the web. As I said, I just got a new version that's different. This meant that the phase-in would be incredibly long. And so, for example, if the statute had been passed in late 32 and FDR comes in 33, the phase-in would have started in 1947 and ended in 1965. If it had happened when Kennedy, if the last year of the Eisenhower administration had been passed, phase-in would have started in 1991 and not yet be over. If it had been passed in the last years of Nixon, it wouldn't be phased in yet. It wouldn't even started yet. Their new proposal provides for phase-in that starts after 10 years. This will result in no grandfathering, so they've abandoned grandfathering of existing justice, and a longer phase-in on average than either the other 2 main proposals. Our proposal, 18-year term limits by constitutional amendment. Terms expire on July 1st if they're recessed for the summer, otherwise beginning summer recess, and if they choose not to recess for some reason, then it's October 1st. Presidents are grandfathers. Existing justices are grandfathered for life tenure. After phase-in, replacements serve the remainder of an 18-year term like the Virginia proposal. The phase-in on average starts in 1 year and ends in 21 years. Compared to 27 and 45 for the Carrington-Crampton proposal, and 1 and 17 for the Virginia proposal. Let's see. So, what are the things that we think that are different from some of the others? Ours is by constitutional amendment. The terms start in odd years on July 1st or beginning of summer recess if later. Presidents grandfathered, existing justices grandfathered for life tenure, and after phase-in, replacements serve remainder of 18-year term. Basically, we have a moderate length. Sure. There's signs here if you want to.
I know. I moved up here because
here you go. So that way you don't have to sit and shout. So. Okay. So basically, the differences is by constitutional amendment, president's grandfathered, existing justices grandfathered life tenure, moderate length phase-in. I mean, this is a long-term problem, long-term solution. So I don't think phase-in length should be overwhelming, and all appointments in phase-in are to at least 18 years. Now. Just to explain, our phase-in is and I'll take the last minute just to explain that. Our phase-in is if let's say it would take effect in 2009, if someone were to die or resign that year, then they would be put in the slot that starts in 2009. If someone were to die, the next person to die or resign were in 2014, and they would be put in the slot that starts in 2015, and they would be given the additional year between 2014 and 2015. And so you take the next open slot. That's the basic way it would work. Okay, that's I guess Ward's not going to talk so much necessarily about some of these things, but he's going to talk more generally about whether we should be tinkering with this long-standing structure. I don't want to say long-standing practice, because my sense is that in fact our proposal is to return to a long-standing practice where terms end after about 15 or 16 years. Thank you.
Thank you very much. Ward, are you going to do it from here?
Yeah, I'm just going to
stand up over there.
I'm going to stay over here. Yeah.
Okay, fine. And I'll come over here.
Okay, so I don't deny that the meaning of life tenure has changed. Of course, that doesn't imply that it's gotten any worse. It may have gotten better. I think it probably has, or in any event, I don't think it's clear it's gotten worse, and I would want to have that clear before I started changing the Constitution. For one thing that the changes Jim has described has done, they have made it take longer for majorities to get their way on the court by replacing justices, because opportunities for replacement occur less frequently. I developed this idea in my paper at some length. I'm going to assume familiarity with my paper, even though I know some of you have read it, some of you haven't. It'll be more interesting, at least for me, to talk about some other things I didn't get to in the paper. We can talk about the paper during the panel time if you want. So one thing I say in the paper is that life tenure is a word that labels a regulatory regime for the Supreme Court, and it covers a lot of different features of it. One is that justices serve long terms. Another is they serve terms of varying lengths. One consequence I did not discuss is that what life tenure has always meant is that all these features of the Supreme Court are beyond the reach of the legislature to change. In other words, life tenure has always been understood as a constitutional rule that justices can serve as long as they please or until they die. That is a feature that will be changed by the Carrington-Crampton proposal, so I want to begin with that. What have been the consequences of treating this as constitutional? I think the consequences have been excellent, although mostly invisible. They've been things that have not happened. So for example, in the moments of the court's greatest unpopularity, you have never had a rush to change their term lengths to get rid of them, to get rid of the justices. By reducing it from 18 years to 9-year terms or to 2-year terms or anything else. I'm glad we haven't had that. Why have we not had that? Is it because no Congress would be so rash as to try something like that? To that possibility, we now have a one-word riposte, right? Shivo. So I don't think it's for want of rashness. Is it because nobody would be so stupid as to want such short terms? That can't be it either. We have distinguished people like Judge Silberman, John McGinnis, Sai Prakash, who all advocate very short terms. So it's not because the idea is stupid or because Congress isn't rash enough that we never had attempts like that. It's because the rule has always been thought so clear that it wouldn't admit of such shenanigans. And I think it's a study in the value of very clear rules about separation of powers. You don't want to have these rules about the relationship between the court and Congress be sort of general or left to the spirit of the provision to be worked out. You want them very clear so everybody knows where they stand and there's no monkeying with them when times get heated. My view of the statutory proposal is that if it were enacted, once you admit the principle that life tenure is satisfied, even if you move people on and off the Supreme Court, as long as they're still on the federal bench, I see no principled stopping place between that and very short terms. I just don't see how you do it. I don't even see much of a principled stopping place between singling out individual justices and saying, we're moving right now from the Supreme Court, we don't like you anymore, but you will still be on the Federal Court of Appeals, so you'll still have life tenure and the Constitution will still satisfied. I don't doubt there are ways you could try to distinguish those cases from the 18-year proposal, but they're too amorphous for me. I want clear rules about this kind of thing, and I think we usually have those. All I would say beyond that is I don't actually think 18-year terms done by constitutional amendment would be a horrible thing. I'm not convinced on the need for them. I'll be arguing that next. I do think doing it by statute, establishing the principle that Congress can tinker with this by statute, is a very grave thing. And that's something I think worth fighting hard against. And Steve Calabresi thought it was constitutional. Now he's changed his mind. An legal academic changing their mind, not something you see every day. I hope those of you who have already signed on to this proposal will find strength in Steve's example and consider changing your minds as well. Okay, what other consequences of life tenure should we be talking about? I think life tenure has given us ideologically more moderate justices than 18-year terms will. This for two reasons. One is life tenure makes the stakes very high of an appointment. So of course presidents have to worry about resistance in Congress. They tend to play toward the middle. I think this is admitted by Steve Calabresi and Jim Lindgren, although they don't put it in this way. What they say is 18-year terms will reduce the rancor of the confirmation process. What do they mean? Why would it reduce the rancor? Is it because presidents will appoint more moderate justices? No, of course not. That's not. They would have no incentive to do that. What they mean is Congress will let people go by who they would not now let go by because they won't be as worried because they'll only be there for 18 years. What does that mean? It means the margin, guys like Robert Bork, who got blocked before, might get more likely to get through. That's all it can mean when they make this argument. Is that a bad thing? Well, not necessarily. I mean, Steve wishes Robert Bork had gotten through the first time. Probably some of you agree, some of you don't. I don't actually have a big dog in that fight, but what I do want is for this issue to be openly discussed and addressed. I mean, if this proposal is actually going to go forward, I think the country is entitled to a debate about what it's actually going to mean for them. One thing it's going to mean for them is, if the proponents of it are right, are more ideologically extreme justices. This for another reason as well. Another way life tenure has made justices more moderate is that Congress has felt more willing to oppose nominees they don't like. Why? Because chances to appoint them fall to presidents by grace, not by entitlement. Somebody happens to die when you're the president. Okay, you get to replace them, but the Senate doesn't have to feel that you have a right to replace them. They can second guess your choice. Steve says in his paper that I don't take the Senate's role seriously enough. No, I take it more seriously than you guys do. I think the Senate's role is critical and can actually help address a lot of the problems life tenure is said to create. What I believe is that Steve and Jim's role, again, by their own admission, will have the effect of reducing the Senate's role. This other way it will reduce it is a president will be able to say, look, I won these appointment chances fair and square. Every president gets 2. I won the election. Give me what's mine. No president can say that now, but they will then. Next consequence. What about the substantive consequences of life tenure? Here's a very important issue. It's hard to discuss precisely. How is our law different because justices have had life tenure? We should not pretend we know exactly, because we don't. Nobody does. We're not experts on this. There probably aren't any experts on figuring out how justices think differently when they know that they're there for life. But here's the thing. Everybody to discuss this has the same view of what the effect has been. We can argue about the magnitude, but the direction seems clear, whether it's Prakash or Silberman or Calabresi and Lindgren. Everybody who talks about this says life tenure makes judges, well, as they put it, more activist. Now, of course, that's a pejorative. It's a somewhat of a tendentious way to put it. It assumes the truth of the interpretive philosophy favored by the person doing the talking. Jeff Stone has the same view, but comes at it differently. He said in my discussions with him, oh, well, yes, what it means with life tenure, justices actually have the time to learn what the responsibilities are. Okay? Another way of saying the same thing. The decisions tend to become more liberal, more protective of liberty at the expense of democracy. Steve thinks it's a bad thing because they become less legitimate. Again, many of you may agree. Some of you, I have no doubt, disagree. This has to be part of the debate. If you're going to try to get this past the public, I think the public has a right to a debate about whether they want, in general, to commit themselves to a Supreme Court that tends to be more conservative for the next, well, for some unknown hundreds of years. That is the likely effect. I repeat, everybody to weigh in about the effect of this on the substance of the court's decisions agrees that's the likely effect. They disagree only about the magnitude. Do we want that? That's a consequence to discuss. Outplacement. What do we do with these people after they're done being justices? Under 18-year terms, the thinking is, well, they'll have other things to do. We'll keep them on the Supreme Court in the background. Maybe they'll read cert petitions. Maybe we'll have them judge Court of Appeals cases. Maybe they won't want to do those things. That occurred to anybody after being Supreme Court justices. Right now, because of life tenure, people say, you know, Justice Kennedy does what he does. You know why he does it? He does it to keep his friends happy at Washington dinner parties. But you know what they don't say? They don't say he's angling for an ambassadorship because they know that he's going to stay there until he dies or until he can't do the job anymore. But if he's out of there after 18 years, when would his term expire? This year. He'd be done right now. And instead of everybody talking, all my Federalist Society friends talking about how Justice Kennedy is pandering to his dinner party friends in Georgetown, they'd say he's angling for an ambassadorship or some job in Austria like that. Now, I don't think that's true of Justice Kennedy, of course, but the point is, over the long run, you'll hear more about that because you'll have some young appointees who will be finished with their time on the court when they're still vigorous. And then the question is, will they be angling for jobs? Sometimes they will be over the long run, and sometimes they won't be accused of it. That's a bad thing. We have these various consequences of life tenure, some of which I've discussed, some of which I haven't, and we can talk about more of them. What's on the other side? I mean, those are I've talked about what I consider some positive consequences of it, or at least some that many people will think are positive. Is it creating problems? Steve and Jim say there were 7 times their proposal is a Burkean one. I don't think there's anything Burkean about it. I agree that their proposal would, in some respects, restore things to the way they used to be, but Burke wasn't first of all, who cares what Burke would have done, right? But I like Burke, so let's talk about it for a minute. And I think the Burkean mood of prudence is the right spirit in which you approach a question like, should we be horsing around with Article 3? So let's think about it like a Burkean would. Burke wasn't about going around enacting reforms to make things more like they used to be. Burke was about taking prudential, incrementalist approaches to problems and asking whether the current situation is really such a crisis that we need to make these kinds of changes. How are we doing on time?
You've got 6 more minutes,
Great.
7.
How serious is that? That's my view. I have a pretty strong presumption against changing Article 3 unless we can show it's causing serious problems. So how serious are the problems? One reason I have this reluctance is just temperamental. One reason is that that once you start putting the hood up, as it were, in Article 3, there's other mischief that you can imagine being attempted to it. But in any event, I tend to favor incremental solutions myself. So let's talk about some of the problems that have been cited with credit caused by life tenure. Steve and Jim say, well, one problem is the exclusion of, I'm quoting, the exclusion of the most experienced potential nominees our nation has to offer, such as 60-year-olds. Presidents won't appoint 60-year-olds anymore because they're too old. If you have life tenure, you want to appoint somebody young so you get more mileage out of them. Of course, it's just false, right? Ruth Ginsburg was 60 when she was nominated. Robert Bork was 60 when he was nominated. What I think is true, I think the reason Steve falls into this trap, if I may say, is that he thinks no president in his right mind would appoint a 60-year-old. He wouldn't. He wouldn't advise it. He'd say, are you crazy? He thinks Bill Clinton was crazy or stupid for appointing a 60-year-old. The thing is, they do it. One reason they do it, of course, and I mean, if Steve was around for the Reagan years, they might think they're better off with 20 years of Robert Bork than 30 years of Anthony Kennedy. And they would, Steve, I'm sure, thinks that. And that's the reason to appoint a 60-year-old sometimes. Anyway, it's just a false claim. What about decrepitude? Again, there's exaggeration in the paper. He says, how do they put it? 60% of the last 5, I always think it's strange to put a percentage on such a small number, but 60% of the last 5 justices have been mentally decrepit when they left the court. They use the word mentally incompetent interchangeably. That's too strong. It's not supported by David Garrow's article, which they cite. Thurgood Marshall probably was mentally decrepit when he left the court. All that can be said of William Brennan is there's a quote from a biographer saying he nodded off during oral argument more than once. I don't like to hear that. It's not the same as saying he was mentally incompetent. Lewis Powell, he wasn't mentally incompetent. What's true is he had physical problems that sapped his energy and made him less effective than he formerly had been. He wasn't mentally incompetent. At least David Garrow's article, I don't think, supports that particular claim. I may sound like I'm nitpicking, but look, if we're trying to decide how much of a problem life tenure is, we should be precise. That's what Burke would say. He'd be very impatient with exaggerated claims about all the problems life tenure is causing. He'd say, are you sure? Let's kick the tires of these claims. I'm kicking the tires and I don't like what I'm finding. They say confirmation battles under life tenure for the Supreme Court are inevitably bitter. They're not inevitably bitter. The last 2 weren't bitter. And they say, okay, well, we'll add a parenthesis. If the Senate's in different hands than the president. That's not true either. You think Ruth Ginsburg's confirmation would have been bitter if it had been in 1995 instead of 94? I don't. Certain battles are very bitter. The Bork battle was bitter. If you try to do certain things, you get a bitter fight. Well, you should get a bitter fight. It's a big deal. You're trying to make changes in things people care about. I don't see it as being a problem. But in any event, I don't see the bitterness as being a problem. We may have bitterness in the Court of Appeals nomination fights, but it's not clear how their proposal is going to help that. They say life tenure has undermined the ability of the president to do his job and the courts. They just say this, but how? The court seems to be like it's doing its job, so is the president. What do you mean? Be specific. Show me the evidence. Where's the trouble? Where's the problem? What are you talking about? Now, there is one serious problem I think life tenure undeniably creates. And they don't make much of it, but it worries me a lot, and it makes me almost want to have fixed terms, which is that some presidents get lots of nominations and others don't. If I were arguing your side of it, fellas, what I'd say is Richard Nixon and Ford together, treat that as one presidency, got 5 picks and Carter got none. And that's absurd, given the amount of power the Supreme Court has. I find that argument very moving, and it's an example of a nonpartisan argument. I sometimes hear it said, the case for fixed terms is nonpartisan. To me, that's just marketing, it's labeling. What's true is there are nonpartisan reasons for wanting this, and there are partisan reasons for wanting it. If I were a federalist and I wanted Roe v. Wade reversed and I wanted fewer decisions like it, I would want fixed terms. I think they make that more likely. They don't guarantee anything, they make it more likely. Of course, there are other reasons to want fixed terms that have nothing to do with that. So some people want them for partisan reasons, some for nonpartisan reasons. We should discuss all the reasons and all the consequences. Let me be more concrete. Where are we on the time? Just so I know what.
2 minutes more.
2 minutes. I believe, let's go back, think about fixed terms. If I'm right, and if Steve and Jim are right about the consequences of fixed terms, how would things be different now? Well, during Ronald Reagan's 8 years, he would have gotten 4 appointments, and he would have gotten more deference on those appointments. I repeat, these are the suppositions of their argument, because the Senate would have been less rancorous, because they wouldn't have been worried about life tenure and so forth. Had you done that, had Reagan gotten 4 and the Senate showed more deference, I think you would have had quite different, and then Bush 2 more, six in a row. I think you would have a quite different and much more conservative Supreme Court now than you have. Of course, Clinton would have in the meantime gotten 4 more, but only 4, and then you'd have Bush now. Hard to say what the result would be, but I think on balance in the long run, you'd be looking at less liberty, maybe more legitimacy, if you take Steve's view of what these people ought to be doing up there, but probably less liberty. And I think that's a consequence that's much more important to the American people than interpretive theory, although Steve and I apparently have a disagreement about that as well. Okay. Oh, yeah, the one last thing. Stephen, one more point that I find objectionable is the last line of Steve and Jim's paper. They compare the Supreme Court to the Chinese Communist Party, gerontocracy. Look, folks, that's not Burkean, okay? It's an exaggeration. We would not feel better about the Chinese Communist Party if the members served fixed terms of 18 years. That's my hypothesis, okay? Enough.
Well, do the other panelists have a comment?
Yes. First, I guess I want to say that part of what Steve is going to be doing this afternoon is responding to criticism proposals, and since Ward has been, as we've just seen, the most eloquent opponent, he will be dealing primarily with it. But I'd like to just comment on a couple of things. One is, and I don't know if this is still on, but one of the slides that didn't, yeah, let me just go to one of the slides here. But in a sec, as far as the Chinese Communist Party, I thought that was a great line of Steve's, and it tells a story.
Oh, it's a great line. I agree there.
Hold on. The Chinese Communist Party, I think, actually has an 80-year life age limit. So the Chinese Party, I think, is a little bit ahead of the Supreme Court in this regard. So maybe it's an unfair comparison because they're actually doing something about it, and we're not. I think that that it isn't just that they're communists that people find it odd. They think it's odd to be ruled by such an odd leadership cadre. Whatever, and it's because it's a non-democratic society that we feel that happens. So it's not unrelated to the point that we're making. Now, as far as the decrepitude, I guess I both agree and disagree. Certainly, it was one of the last things we were sort of working on, and we decided that we had been too strong in some of our statements. But given our conversation last night, and we were talking about some of the extraordinarily feeble people who I don't know whether you can call them mentally incompetent or not, but certainly were not functioning at a very high level for a long period of time. I'm not sure that the physical decrepitude isn't a crucial point, and certainly those who've clerked in the late 80s or clerked now recently do report serious problems with justices seeming to be too feeble to do their work. So I do think that is a potential problem.
If I may, a very brief reply to that last point. You guys reject an age limit for what I consider arbitrary reasons. You say it's too harsh and unfair to these justices. I don't know what you're talking about. They have no right to be there. I think an age limit, there's a pretty strong case made for an age limit of 80. It would be a more direct way to get at the mental decrepitude problem. I point out Lewis Powell, who had these problems you described, he had them in his 16th year. Your proposal wouldn't even help that. So he's not a good example for you to cite. An age limit would be, in my view, a more parsimonious way to address this problem if it really is a serious problem. And I, in my papers, say I think there's a pretty good case for an age limit.
I have a question for Jim, and I guess for Steve too, if he agrees. Your transition and delay figures for the Calabrese-Lindgren proposal and for our proposal seem to me to be wildly off. As I understand your proposal, it only becomes effective when a new president's elected, and it never applies to the justices at that time. And you know, if you have all of these data about if it went into effect at a certain time, we'll assume it went into effect today. Let's assume that Bush gets 2 more appointments to the court, and there are 3 very relatively young people now on the court, that is under 60 or so on.
Everyone but one's is 65 or older.
That's right, but they were in early 60s.
No, everyone but one is 65 or older.
Well,
late 60s.
But they still have a very substantial longevity of 20 years, and a new appointee would likely have a longevity of 30 or 40, who knows, 40 years with medical care the way it is. So it's postponed until that.
Then any new appointee who would come in would be put in an 18-year term.
But not until the new president is elected.
Oh, you're saying if it was passed,
if it passed today, and Bush had 2 more appointments, and then you have the Thomas, who's the youngest, and might be there for for some 20 more years, and I think the transition would be very long. But
we took the transition to be. You're right. We took the transition to be when a new president came in, since that's what it was based on, and so ours. So you're saying that if it were passed today, then there would still be till 2009 for an appointment that could be a very long appointment.
And there likely would be other new appointments before, in effect, even if it was the next president's term, and then because there'd be another 4-year period in which presumably some appointments would arise. Comments, Steve? I'll give talk on you because the words and remarks were directed to you.
Maybe I should stand to be heard. Ward made a number of really good points, and I really appreciate his kicking the tires and pointing out all the arguments that can be made against the proposal. I think that's what needs to be done in debating any constitutional amendment. Just a few quick thoughts in response to each point that Ward made. First, he says 18-year terms will lead to more extreme nominees. I'm not persuaded that's the case. I think the stakes will still be very high if you're appointing someone to the court for 18 years. Senators clearly think the stakes are very high right now just in appointing people to federal courts of appeals. If they're willing to filibuster federal court of appeals judges, I think they'll be willing to filibuster someone who's going to serve for 18 years on the Supreme Court. We actually have evidence about what happens when people serve for 18 years on the Supreme Court, because between 1789 and 1970, justices served an average of 14.9 years. And during that time, there were confirmation fights with some frequency in terms of filling the court, and people's expectation would have been presumably that a justice would serve about 15 years, and there was an extreme deference. Second, you say presidents will feel entitled to their 2 picks and the Senate might defer too much. Again, I think the same response might be made. The Senate doesn't defer now on Court of Appeals nominees to the president. Why would they defer to his 2 picks for the Supreme Court? And again, during the period between 1789 and 1970, on average, every president got to make 2 Supreme Court nominations, and there certainly was resistance in the Senate on average during those times. You mentioned that justices might angle for other jobs after the completion of their 18 years. Well, if the average age of appointment stays at 53 years, which is what it's been consistently over American history, then after 18 years, justices will step down at age 71. Very few 71-year-olds will be looking for some major new job or career to pursue. And actually, it's possible under our proposal, I think, that the average age of at appointment will become somewhat older because of the 18-year limit, in which case justices would retire at an even later age and be less likely to angle for other jobs. You disagreed with us that our proposal was Burkean and said that, in essence, if it ain't broke, don't fix it, and Burke would have endorsed the presumption against change. I would note that Burke was a defender of the American Revolution as a restoration of the way things used to be. I think Jim's and my proposal is just a restoration of the way things were between 1789 and 1970. In that sense, it's a return to past practice. A couple of other points. You defended the idea of an age limit in the Constitution instead of an 18-year term. My problem with an age limit is that I think numbers in the Constitution tend to wear very badly over time. The 7th Amendment protects the right of jury trial at common law where $20 or more is at stake. That's a number that has aged very badly with time. If we write a 70-year-old or 75-year-old age limit into the Constitution, it's quite possible that 100 years from now, people will be living routinely to be 100, and we will have picked the limit too low. So I'm wary about putting an age limit in the Constitution. Beyond that, I do think that people age at very different rates, and there are people who are extremely healthy in their 60s, 70s, and even 80s who might be able to do the job, and I would not want to exclude those people. Those are just some initial responses. There are additional points to be made, but that...
Yes, of course. Well, if I may briefly reply then. First of all, on the question of whether we get more extreme nominees, you say, oh no, the Senate would resist just as much then as now. You're just arguing against yourself. Your paper goes on at great length saying the reason we need fixed terms is because of all the rancor in the confirmation process. This will reduce them. Now you're saying, oh, don't worry, there'll be just as much rancor then as there is now. What's it going to be? I mean, I'm just taking your argument on its face and assuming it's true. It seems to me that if there's less rancor, all that can mean is the Senate's letting people through more easily.
No, no, it doesn't, though, because...
What are you talking about?
You're assuming only one side of it, and we're focusing mostly on the other side. You're assuming that what this means is that the president's going to be more aggressive.
Of course.
And what we're suggesting is that the Senate and the populace is going to be less aggressive because the stakes, in terms of time, they feel less strongly they have to fight it to the death.
Yes,
The
exactly.
president's already pretty aggressive.
No. Your proposal would give the president zero incentive to be less aggressive. It gives the Senate less incentive, but the president doesn't change his mind.
I think the rancor in the confirmation process is not only due to the length of time that the person will serve on the court, but also to the predictability about when the vacancies will come up. And I think that the current system, which has hot spots, so vacancies sometimes come all at once, and sometimes you go for a long period without them, makes senators very anxious about the court getting locked up by a group such that it will take a very sustained campaign to turn it around, a campaign like the one progressives had to wage between 1901 and 1937 to turn around the law.
That's plausible. I still think the bottom line, well, I think the bottom line is that it'll be easier to get people through, and I'm actually more persuaded by your article than you seem to be. You asked why would the Senate defer more? They don't defer now in courts of appeals judges. They didn't defer in the old days as much. Of course, they did defer more in the old days, but never mind. The point is, it's a matter of entitlement. These proposals are pitched as every president gets 2. That's part of the point. We don't want an arbitrary assignment. Every president gets 2. Every two-term president gets 4. I think when you keep saying that, you change the mood that occurs when a president takes his 2 picks. They're spoils now. You made them the spoil of a presidential election. They aren't spoils now in the same way. That's a difference. Even if they used to get 2 and 4, they weren't spoils. Now they would be. Angling, I want to be quick so more people can talk. You said, will justices angle for jobs afterwards? No, you say the average age is 53. They'll leave in their 70s. They won't want other jobs. You're thinking about average justices. Don't think about averages. Think about margins. Of course, the average one won't change. The average one doesn't care about angling for anything. At the margin, you will get more of this, some of this effect, and more of it. That's how incentives work. I mean, you'll get some 40-something-year-old appointment, some Miguel Estrada or something. He'll be finished when he's 60, and he will have an appetite for more. And he won't be content to sit around in some court of appeals someplace. I'm not suggesting Miguel would angle. I'm just saying, over the long run, you will get some younger appointees who will retire at an age where they're still vigorous, and they will perhaps be accused of angling, sometimes justly, sometimes not. I'll leave it there.
A question for you, Ward, because I don't think you dealt with it or mentioned it at all. You, I guess, would agree that justices of the United States do not have an appropriate role in the appointment of new justices. But one of the big problems of current arrangements is the indication and evidence over the years and increasing as time has gone on of justices delaying their resignation or speeding it up and so on in an attempt to have a like-minded president appoint a like-minded judge. They have absolutely no constitutional authority or authority of any kind to help influence those decisions, and yet it's a very important factor in the present system.
I grant the force of the point. I say in my paper that I think the spectacle of justices retiring strategically and trying to, in effect, name their own replacements is deeply troubling. So, there's some good reasons to want to do this. I also think it's not that serious a problem. I mean, what's the evidence that it is? No, in practice, it has not been that serious a problem. It just hasn't been. There have been very few seats that have been stayed in the hands of one party for lengths of time.
Sandy Levinson, who's arrived now, fortunately, wants to respond to that.
If you want to respond to that, I'd like to hear you.
Well, I read your paper on the plane coming down, and I think...
A little louder, Sandy.
I read your paper on the plane coming down. I think it's the best statement for the life tenure position, but not surprisingly, I think it fails. And what I found most devastating to your own argument is what is on page 20, where you point out the consequences of selecting younger judges. And so that a political party, and it is a political party, that selects younger judges, even if you have fairly stable my turn, your turn occupation of the White House, will over time get a huge edge. And it seems to me there is no plausible defense for building into a system not only the gaming of resignations, which I think has very serious consequences, contrary to your view, but also building into the system an incentive to appoint young.
Well, first of all, as I feared, you weren't really wanting to speak about strategic retirement so much. I'll talk about the point. I just want to finish that point quickly, and then I'll talk about what you raised. On strategic retirement, I grant in the paper it's a serious potential problem. I want to see serious evidence that it's creating a real problem of capture of a seat. I think there are occasional justices who've tried it. I don't think it happens very often. Anyway, I also add, I think age limits would deal with a lot of the problem.
Okay, just the rest of that point.
Yeah.
I mean, and this gets to the mental decrepitude point. Justices Marshall and Brennan simply stayed on too long by any conceivable rationale, ranging from politics, knowing what we know now. They really should have resigned during the during the Carter administration, at which time they still would have had, especially Brennan, ample service on the court. But they stayed on long after they were really able to perform their job. And it seems to me that's a serious cost.
It is, so have an age limit. An age limit of 75 would deal with both problems by getting rid of these people before they become decrepit, as you say, and probably it would deal with strategic retirement, because most of them would stay around until they're 75. Let me briefly deal with the other point you raised, because I think it was important. In my paper, as you note, I concede that one thing life tenure does is it makes different justices have radically different impacts depending how young they were when they were appointed. Clarence Thomas is going to serve for almost twice as long as Ruth Ginsburg, probably, which is an amazing fact when you stop to think about the implications of it. I don't think that's a horrible, devastating point. Of course, I discuss it at length. To me, it's just something to be aware of. It is an interesting feature of life tenure that when you pick somebody, one of the moving parts is you're picking them for varying lengths of time. And should a president be a president, when he appoints Clarence Thomas, is saying not just I want Clarence Thomas, but I'm going to try to fill this seat for this many years. And that ought to be as much of a source of discussion and object. Look, let me be frank. I think this amendment's probably not going to happen, okay? Getting rid of life tenure. So in the meantime, I want to make this point because we're all going to be stuck with life tenure anyway. And with this devastating situation you described, Sandy, we're in it. We're going to probably stay in it. We ought to be discussing it more. When the president appoints somebody, their age and their expected term length ought to be a major feature of the discussion. It's now rarely a feature of the discussion, but I don't mind a system where it is.
Scott Poe.
I'm troubled by the incentives to go young. It seems to me that they're perverse on that. Let's lock up a seat for 30, 40 years. My instinct is that if it were an 18-year term, you wouldn't see a William O. Douglas being appointed to the court. That he would look at that and say, I'm going to be 59 years old when this is over. That's not a good time for transition. And he'd stay within the executive branch. So I think there would be, under a term, I think we'd get older appointees, and I think that's a good thing. I think I would like on the Supreme Court a more fullness of experience, and you get that on two different ways. One, by aging, and two, by not being on the Court of Appeals. I think it's positively perverse to deny excellent lawyers who are either in private practice or public service the opportunity to be on the Supreme Court because they weren't on the Court of Appeals. So I think if you went with an 18-year-old term, I think we'd be seeing appointees in their mid-50s or so.
Well, first of all, we now do. That's what we usually see now, people in their mid-50s. This idea that there's this incredible incentive to appoint young people, look, what can I tell you? The facts don't bear it out. Presidents keep appointing people in their 50s and up to the age of 60. Some appoint very young justices. But what's the Burkean answer? If we have this problem of appointing people who are too young, what's the incremental answer? Get in there and oppose it when they try it. I mean, Steve, where were you when Clarence Thomas was appointed? You should have gotten up there and said, this is a fiasco. You can't appoint somebody this young and tie a seat up. And I'll tell you something. If you want to make a difference and you want to do it incrementally, next time some president tries it, oppose it, especially if it's somebody you like. Because then you actually have some credibility, and which academics almost never have because they almost never do this. But get in there and oppose your friends and say, this person's too young and it's wrong.
I think Jim wants to remind us of some of the statistical information bearing on this question.
You asked for evidence, and it's mentioned in the paper.
It's mentioned in my paper. There's a study.
It's basically the relative odds of a justice resigning while the president of the same party compared to the odds of justice dying while the president's the same party are 2.7 to 1. So it's almost 3 times as likely. And if you look just on resigning, because dying in office is rare these days, look just at resigning, it's 1.8 to 1.
I don't deny that that there's some tendency towards strategic retirement. One justice was quoted as saying, "You go home with the lady you came to the dance with," which is an odious sentiment, but there it is. What I deny is that as a practical matter, it's led to serious trouble. But look, I repeat.
That's some evidence. It's very strong evidence, it seems to me.
But there's 2 parts to this. One is that it's almost twice as likely that they succeed. And as Sandy points out, even when they fail to do it, there can be serious consequences.
That's right.
When they succeed, it's bad, and when they fail, they may stay on too long, hoping they'll get a chance to do it.
I grant the force of the argument. I repeat, an age limit is a simple way to deal with it.
Tom, because they haven't gotten in, and then we'll go back to you. Then to this man in the back.
I'm going to be quite brief and shift it a little bit. I'm tempted to ask Steve to announce his opposition to Jay Wilkinson right now on the grounds that Jay's too old, but we'll leave that aside. Jim, I would like to see if Jim will acknowledge what I think.
David, I'll do anything you want.
No. What I think is a very sort of happy coincidence of your periodicization, if that's really a word, because in drawing your line at 1970 to delineate the most
it
modern...
includes the carryovers from the early years of the early years of the appointments of under FDR.
Yeah, I don't want to quite go so far as to use the verb cooking, but I think when you end up with the sort of unexplained demarcation at 1970, where you get Black, Harlan, Douglas into the post-70 area, post-70 period, I'd be curious. I don't have close to the quantitative skills to do this, but I'd love to see how much your numbers would change if the line was drawn in 1972 or 1976, because I think my strong instinct is the quantitative strength of your numbers would look measurably different if the line slid a few years.
Tom Miro, why don't we get, I think they're all fine, and then we'll give you a chance to reply to all of them.
Somewhat related, actually. I wanted to ask Jim how much the jump up to 3.75 on that graphic, and also the jump from 14.9 to 26 on the other graphic, is a transitional phenomenon. If we assume that life expectancy increased by 10 years within the last quarter century, and if we assume that it's not going to increase another 10 years in the next quarter century, how far would those numbers go down once we've adjusted to the longer expected life expectancy of people who get nominated to the Supreme Court?
Well, life expectancy...
Would it go back a little bit toward, not all the way, but to go back somewhat toward the long term?
Well, life expectancy hasn't... One of the main things that I discovered in looking at these data is that the demographic story, which had been the primary story before, is not what's driving things primarily. We assume that with longer life expectancy that was really what was going on in these cases. Longer life expectancy makes this possible, but once you've reached age 40, the first data we have in the United States is from 1850, Massachusetts data. I think for those who reach age 40, people are only living 9 years longer than they were in 1850. So that the life expectancy increases are mostly on the bottom end. So there has been an increase in life expectancy, but it's not being driven by that. So I don't think I could redo the numbers in such a way to give you a more precise answer, but it's not going to explain those kinds of things. I don't think that's a transition in that sense. I think it's a transition in a different sense, a political sense, is that the stakes, people began in the 60s to understand the stakes that were involved in the court. I think that's it. Now, in response to your question, this table is not based on any periodicity, and that was one of the reasons I wanted to put it in. I'll explain how I did the periodicity and why I chose we originally did the data through 2000, so that broke more neatly into 30-year periods originally. And I ran 10-year periods, 20-year periods, 25, 30, 50. And one of the things, if you're taking what is a sort of a continuous variable and you're converting it into categories, essentially, although they're time-based, or intervals, essentially, is creating, is that you want to make sure that you don't hide whatever the pattern is in there. So there's no question that these were shown in such a way to reveal the pattern that was in the data. That's what you should do. Now, you can argue that when you're doing statistical significance tests, that can be more of a problem. But in terms of revealing the pattern in the data, that's what you want to do, and that's what I did. There's some numbers, but that's one of the reasons for having tables like this as well, which don't have any such defect at all. These shows everyone, there's no picking. As you see, we see the same jump when you take this out, because that's the pattern in the data. So when I pick periods to tell the same story you see when you don't pick periods.
The gentleman in the back had a question.
Yes.
Would you please introduce yourself just by name?
I'm Philip Oliver from the University of Arkansas.
And you wrote a great article and proposal.
And haven't thought much about it since 1987 when I wrote it. But on the issue of the strategic retirements, I think there's quite a bit of evidence that at least justices try. And even if they make the effort, it may be getting them off the court when we don't want them to be getting off the wrong time. And the age limit idea doesn't do anything about the situations in which justices speed up retirement, which may well have happened with the last two Supreme Court chiefs. Most notably with Earl Warren trying to get off in time that Lyndon Johnson could name his replacement rather than Nixon. It didn't work, but it was clearly an effort on Warren's part to strongly influence who would succeed him. It's very likely that Warren Burger left a little bit early for the unusual reason, not that he saw a change in the presidency coming, but that he was concerned that the Senate would change hands, which in fact happened with the result that Bork went down when he would not have had the Republicans still been in control of the Senate. We have seen Douglas obviously holding on a long time. We saw Taft, he got it wrong, not wanting to leave the court when Hoover was the president because he was afraid, I have to stay on because the Bolsheviks will take over if I leave. So he stayed on and didn't necessarily get it right. It also happens even with inferior judges. I know in 1988 in Arkansas, there was a district court judge who very clearly was ready to go and had been for about 18 months. She held on because Democratic Senator Bumpers, who had arranged her appointment in the first place, said, wait and see who wins in 88 so that I can name your replacement after the 88 election if Dukakis wins. Dukakis didn't win, and so instead of waiting until January, she waited until 48 hours after the election and announced her retirement. Not the most horrible thing in the world, but still, I think you have lots of strategic retirements that don't come to light. People don't necessarily want to get up and say, I want to go on the record as saying, here's the reason I'm staying on the court, but you just look and see.
Well, if I may, two things. One is, I think you're entitled to some credit, and congratulations, because as far as I know, you were the first to develop in an extended scholarly way the ideas we're discussing here. And I'm impressed by your work on it. Secondly, look, if you read my paper, which I'm not sure if you've had a chance to do, I discuss strategic retirement, and I'm as hard on it as anybody. I think it's a serious problem. It's a serious potential problem. In fact, very few seats have stayed in the hands of the same party for any length of time. And in fact, the problem of decrepitude, although it sounds horrible, I don't consider it to be that serious a practical matter either when you look at how often it strikes and how serious the results are. But look, there are costs to life tenure. These are the costs. My view is there are also benefits to life tenure, and that to get rid of these costs, you've got to change the way the Supreme Court acts in ways that maybe aren't so great. On balance, I'd rather live with the problems we now have and keep the benefits. Others might feel differently. The one thing I'm really exigent about is making sure that if the public's going to debate this, they have a very clear sense of exactly these trade-offs. Fine, they should hear all about strategic retirement and the risks of it. They should also hear all about some of the other things life tenure does that maybe are a little better.
John Harrison.
Two related questions for Jim Lindgren. It seems to me that maybe the most important policy question concerns, like Steve said, hot spots and accidental clumping, like when Harding had 4 appointments in the course of a single Congress. So what I was wondering is, one, is there an intuitive measure of lumpiness as opposed to smoothness that we can apply to what's actually happened over the last few years? And could you, making some demographic assumptions and so forth, do simulations of likely lumpiness and come up with expected lumpiness under life tenure as opposed to the smoothness of most of the proposals?
Yeah, I mean, I'm sitting here looking at I've got the year they leave the court, and I wouldn't know how to personally to do the simulation for such a thing. There's no question that they tend to come in bunches, and as Ward mentioned, Carter not getting an appointment. This isn't just, oh gee, this is too bad he didn't get his at least one appointment. He's the only president who served an entire term who didn't get an appointment. And realize that
George W. Bush didn't.
No, served an entire term but presumably George will get one. But I'm saying that there's no president who served a full term and didn't get one. Doesn't mean that there wasn't there's only a few that had to wait till the second term. I think since 1870, I think Roosevelt's the only one who had to wait till the second term.
Three, I think. Three in our history.
Yeah, but I think since 1870, only one. So it's something that's coming. It seems to be coming up more often here because we've actually gone a couple of terms, though not blocking out a president. I think it's likely that we'll have more appointments in a row in the next 10 years than we've had before. It seems to go in waves. Certainly, there was a strong string in the late 30s and 40s. So I think that the time to appointment tends to go a bit up and down. You can argue that every time there's a peak, there's a drop, but of course that's kind of the function of when you run a thing. It wouldn't be a peak if it didn't drop after it. But I think there's some, and of course we didn't get a drop when we got into the 1980s. Unlike the other peaks, it didn't drop. But the other peaks have all dropped. My guess is we will get a drop, but how substantially, it's hard to know. I'm sure someone would be competent to do such a thing. I'm not.
It's time for our coffee break. We're going to have lots of time to raise questions. This is all an interrelated subject. We have 15 minutes. Promptly at 10:15, we're going to start again. Applause for our two speakers. Good job, Ward. Good job, Jim.
Thanks.